Hi, everyone. Happy New Year. Although I know we're getting into the end of January now, so I don't know if it's really appropriate to say Happy New Year anymore. But this is our first seminar back after the holiday season, and I'm happy to be here and happy to have you all here too. Today, we're going to be talking about trusts. We've talked about this before, and this is actually a topic that we keep doing over and over because constantly one of the number one phone calls we get in our office are questions about trusts. And these aren't people who are saying, do I need a trust or new? But a lot of people are calling because they're taking a deeper look at the estate planning they have already. They recognize that their estate planning has trusts involved in it, whether it's trusts while they're alive or after their death or both. And they want to know what they have, and they want to understand what they have and figure out if what they have has to be changed based on any changes in law or in situation. So today is meant to be a review of some of the trust terms that some of you may already have in your documents, and also an explanation of trusts and why trusts are there for those of you who are looking to possibly create a trust, but also for those of you who are looking to re-understand the trust that you have in front of you. None of this is obviously meant to be attorney advice or legal advice. So we do recommend that you take the concepts you've heard today and you either go have a consultation with an attorney to get advice in your specific circumstance, or go back to an attorney that you've already dealt with to review the documents that you already have and see if there are changes that have to be made. So that's why we're here today, and I'm excited to get to dive right in. What I plan on doing is discussing a topic at a time and then pausing to see if there's questions on that topic, just so that people aren't asking questions a long way after that issue was discussed. So I'm going to get started right away. Why create a trust? The amount of times that I've heard somebody say, well, we're not the Rockefellers, we don't need a trust, is a lot. A lot of people feel that way. They feel like a trust is only for the incredibly uber wealthy. And that isn't necessarily the case. There are a lot of different types of trusts, and they are created for various reasons. So why create a trust? There's a few reasons, and I'm going to give you some of the most common reasons, although this is by all means not an exhaustive list. So the main number one reason you hear a lot of people talking about creating a trust is to avoid probate. So probate, what is probate? Why is everybody talking about avoiding it? What's the big deal? Anytime that somebody has an asset in their own name with no beneficiary, no joint owner, upon their death, either their will has to go through probate if they have a will, or if they don't have a will, there's a court proceeding called administration. But either way, if you own that asset in just your name, there has to be a court proceeding upon your death. So I'm going to give you a very simple example. You own your primary residence. It might be a condo, a co-op, a freestanding home, but you own your primary residence. You're the only one who lives there. You're the only one who owns it. Now, you might have a checking account that you've put a relative joint with you on. You may have a retirement account that you've named a beneficiary on. Those items are going to go to that joint owner or to that beneficiary. But on that house, that residence will need to go through the probate process of your will before it can be dealt with. So what does that mean practically? Well, a lot of times, especially when we see real estate being involved, the problem is everything's in limbo. So in New York City, when you have access to apartments being an issue with co-ops, you have someone who passed away in your apartment. We very often have family members who can't get into the apartment even to start cleaning it out until the probate process is over. We have other people who are concerned because the neighbor came and knocked on the door and they want to buy the apartment or buy the house, and we can't sell it to them because nobody's been appointed to the estate. So probate is the court process of the will, the original last will and testament going to the court with a petition, and the executor who has been named in the document asking the court to appoint them as executor and to approve the will. And that's basically what the process is. And in some places, probate is a very short process. I was involved in something with some lawyers a few months ago, and one of the lawyers from one of the small upstate counties was telling me that the probate process is 3 days, and if she asks a favor, she can get it done quicker. You know, the rest of the room erupted in laughter, because when we talk about Manhattan, we have probates that are taking 8, 12 months. Kings County, very long probate process. And out on Long Island, not quite as long, but it's still not that 3 days. And so sometimes people are really held up because during that time period, someone has to pay to keep the heat on so that the pipes don't freeze. And somebody has to make sure that the homeowner's insurance is continually paid. So these are real expenses that are incurred by that probate process. So if that person who has that property in their name created a trust, and in this case, I'm just talking about a revocable trust. So it's revocable. You can amend it. You can do anything you want. You can be your own trustee. It has your own social security number. You can change the terms of it. You can change who the beneficiaries are. You can change who the successor trustees to you are. You have full control. But remember, I said probate is when assets are in your sole name without a beneficiary. Well, if I take my home and instead of it being Britt Burner who owns the home, it's the Britt Burner Revocable Trust who owns the home, well, that's not in my sole name anymore. And so upon my death, there's no requirement of a court process of probate because the trust document is the entity that owns the house, and the house can then be sold by the trustee. And if I'm no longer living, my trust document will state who is my successor, who serves as trustee when I'm no longer able to. And so that is all right there. And that can be done as quickly as possible without there being this delay of this court process. So that's the number one reason why most people talk about creating trusts is they create revocable trusts to avoid probate. Now, before I move on to some other things, are there any questions? And let me point out that you're not held back. If you ask a question now, you can always ask one later. Liz, I'm not sure how the questions get asked on here. Do we have a Q&A?
We are working on that. I think if someone wants to raise their hand at the moment,
okay.
Maybe we'll circle back to questions.
Oh, great. Okay, take it back. We're having technical difficulties. So we'll keep going. But if you have a question, please write it down and I'd be happy to answer it once we get the tech portion of this fixed up. So another reason we like to create a trust, tax purposes. So what kind of taxes? So mostly we're talking about an issue where somebody is concerned that there is going to be an estate tax owed at their death. Now, I'm going to give you the numbers for 2022 so you can frame in your mind if this is a concern that you or your loved ones may have, or if this is something that's not on the list of things you're particularly worried about. In New York State, if you have less than $6.11 million, so if all of your assets when added together are under that amount, there is no estate tax. Similarly, on the federal side right now, and that's per person, and on the federal side, each person has a $12,060,000 exemption. So just over 12 million is the exemption. Now that's huge, obviously, right? You've got a $12 million exemption. You have two spouses, they can give away 24 million before there's any taxes. I do want to point out that on the federal side, that while that's a very high exemption right now, the current law reads that that will sunset. So for those that are planning now, but don't anticipate, they don't have any known illness, no reason to believe that they will die before January 1st of 2026, they need to keep in mind that as of January 1st, 2026, that exemption is going to go down and it's going to sit probably right around where New York State is, right around 6 million. So if you're planning now, you want to keep in mind that $6 million number, because that's probably what you're planning for both on the federal and the state level if you're a New York State resident. So a few things I want to say about estate taxes. One is the differences between federal and state. So in the federal government, we have what's called portability. So if one spouse dies and they have $1 million in their name, and the surviving spouse files an estate tax return reporting the death to the IRS and checking off a box for what we call portability, then the surviving spouse, when they die, has whatever their own exemption is in the year that they die, plus the balance of what the first spouse died with. So if my first spouse that dies has $1 million in their name, well, then there's an $11 million exemption left over, and that can get carried over to the second spouse. So that's a really great benefit on the federal side. Unfortunately, we don't have that in New York. So in New York, I like to say it's use it or lose it. You either utilize the exemption of the first to die spouse or you don't have it. So we like to make sure we're using that exemption, even though technically everything can go between spouses and there's no taxes. We want to make sure that the entire estate isn't compounded in the second to die spouse's name, therefore incurring a huge tax to the beneficiaries after the spouses are gone. And we're going to talk about how we do that. And that's what we do through trusts. So the other difference on the state side is we have what they call a cliff. It's very dramatic sounding, right? There's no tax, no tax, no tax. And once you hit the exemption amount and you go 5% over that, so you're about 6.44 million, if your estate goes over that amount, you fall off the cliff. This means you're taxed back from $1. There's no exemption. And so you go very quickly from having no estate tax, and then you fall off the cliff and you have a large estate tax. And you could be talking about right off the bat, you know, $1 over the cliff, you could be talking about over $500,000 right off the bat in estate taxes. And so that's something to keep track of when you're doing planning is, are you butting up against that cliff, and is there planning that needs to be done around that? So that's what the estate taxes are. So another reason, like I said, that we often create trusts is to plan around that. Now, let's say we have two spouses and one spouse, everything's joint, right? So they say, well, no, it's going to be simple. If I die first, my spouse is going to get everything. And if my spouse dies first, I'm going to get everything. We like to keep it simple. But what they don't realize is that while they might each have 5 million, if everything goes from the first to die spouse to the second to die spouse, when the second to die spouse dies with now $10 million, maybe more, but $10 million, they're pretty far over that cliff. And if it's after 2026, they're over that federal number as well. And so now there's this big tax because we didn't properly utilize the first to die spouse's exemption. Now, remember, on the federal side, we could have elected portability to say, no, the second to die spouse gets both exemptions. But for New York, we can't do that. And so you may have heard the term bypass trust, credit shelter trust, family trust. These are the different names that we use to describe the type of trust where the assets, when the first to die spouse passes, we make sure that their estate gives up to their exemption amount. So this year, 6.11 million, up to that exemption amount to a trust for the benefit of their surviving spouse. And the surviving spouse can have use of the money in the trust, but it uses that first to die spouse's exemption. So this 6.11 million, it's there, but when the second to die spouse passes, it's not part of their estate. And now only the balance of the estate, and in my $10 million example, just over 4 million is in that spouse's estate. So we had no taxes at the first death because the 6 million was tax exempt and the balance went to a spouse, which is tax exempt. And then when the second spouse dies, now that's tax exempt because it's underneath the amount because it's only 4 million left. And so that's how we're able to use both spouses' exemptions, and the trusts help us do that. Trusts can also be really helpful between spouses because sometimes you have a second marriage or a third marriage, and the spouse may say, you know what, I'm okay if when I die, my spouse needs something, they have access to this money. But then when my spouse dies, I want this money to go to my family. Maybe I have children from a prior relationship. Maybe I have siblings that could use it. So if I'm cared for and my spouse is cared for, I want it to divert back to my people and my beneficiaries. Or in some cases, I've had spouses say, I want it to go to my charities. I don't want it to go to my spouse's charities. And so by creating the trust, you leave that asset available for the surviving spouse. But then when the surviving spouse dies, it goes back to the first spouse's beneficiaries rather than the second spouse being able to determine where it goes. And the great thing about a trust is that everything that I'm saying to you is a choice. Now, there's certain things that have to be in a trust in order for it to operate and have the protections we want it to have and to use the exemptions and all of that. But the choice of trustee has a big question on how the money is spent, right? Is my spouse going to be their own trustee? Am I going to name a friendly trustee to manage the assets for them? Am I going to name someone who maybe is a little unlikely to be spending the money on the spouse? That's a big decision to be made. There's another question of how much access do I want my spouse to have? If they want to empty out the whole thing, is that okay? Do I trust them to do that? These are the kinds of things that will be discussed as you're planning the estate planning to get you to the goal of the document. So the document is the end product. It's, those online create your own documents. That doesn't help you because what you need is to talk through with someone to even understand where are my choices here and what kind of decisions do I have to make now that are going to impact how my documents are drafted and what happens in the future. So that's in terms of tax avoidance. We also often create irrevocable life insurance trusts. That's a way that we take a life insurance policy that someone owns and we put it in a trust so that the death benefit, let's say when I die, my policy pays out $3 million. I might not want that $3 million to be part of my taxable estate, because I might have 4 million when you add together my house, my retirement accounts, my cash, et cetera. If you add 3 on top of that, now I have a taxable estate. Whereas if we can take that life insurance and segregate it outside of the estate through a trust, we can take it out of the estate. If done properly, we can take it out of the estate and now I don't have estate taxes. So that's another important type of trust when we're worried about tax avoidance. And then once we get into the really higher echelons of value of people's estates and very high net worth, we're talking about a lot of different types of trusts. And we might be gifting away shares of a corporation or gifting certain property. And a lot of that's going to be determining what do we want to get outside of the estate really for New York purposes. So let me explain this. The federal government, I'm going to talk about gift taxes now, right? So if I give a gift in New York, there's no tax. And if I live 3 years after I give that gift, that gift is never taxed, not in my estate, nothing. If I die before 3 years, it's going to be added to my estate. It'll be pulled back the value. But on the federal side, you've all heard 15,000, right? So, and this year it's actually gone up to 16,000. If I give $16,000, there's no gift tax filing, no tax. If I give $20,000 to an individual, 4,000 of that is a taxable gift. A gift tax return would be filed, and that gets charged against my lifetime exemption, which is currently over 12 million. So a lot of times when people are doing planning, and especially with the federal so high at 12 and New York at 6, if I have 7, let's say I give away $1 million worth of asset, well, I'm still crediting it on my federal side, but that's okay because I'm under 12 and I'm now under the cliff and I don't have a New York tax. And so there's a lot we can play with, and a lot of it depends on what the value of your assets are and what type of assets you have. So when you meet with an attorney, you shouldn't just be saying, well, I'm worth 12 million. It should be, my assets are as follows. I own shares in an LLC that have this value. I own a property that has this value, but it has a mortgage. I have a bank account. This is what's in it. And really laying it out, because the type of planning we can do is different based on the type of assets that you have. Another really compelling reason that people create trusts, and these certainly are not people who fall into that Rockefeller category, are those that are concerned about the cost of long-term care. So if you are an individual who owns your home, has some savings and a retirement account, and you're living incredibly comfortably, but if you had to pay for a nursing home, which could be $15,000 to $20,000 a month for yourself or for your spouse, if you had to pay that, or if you had to pay for home care, which can be $25, $30 an hour, your income couldn't support that. Your assets couldn't support that. So you need to seek assistance from the Medicaid program so that you can stay in your home, keep your home protected, and have Medicaid help pay for that care. Or your spouse can keep the assets so they can continue to care for themselves, but they're not out of pocket $15,000 to $20,000 a month for a nursing home. For those individuals, we're often creating irrevocable trusts. These are trusts that are drafted so that the creator of the trust, the grantor, the individual who's concerned about getting Medicaid at some point, that person can have access to income from the trust. So if there's dividends that are created by the trust, that's fine. And then also if you have a rental property in the trust and there's income coming in from the rental property, that can go to the creator of the trust. But the principal of the trust, so the bank account that's in the trust or whatever it may be, that can't be accessed by the grantor. Why? Well, think about it. If you could access that money and you could take it out and you could use it, then Medicaid's position would be great. So then use it for your care. You don't need it. And so I think that is really the main, when I talk about the main reasons people create a trust: probate avoidance, tax avoidance, Medicaid. That's what we see most often. And this Medicaid Asset Protection Trust is really important. People put their home in the trust because, sometimes the home is exempt for eligibility, but Medicaid can put a lien on your home after the fact. You may have a co-op, and it could be that years ago, your co-op wouldn't allow your trust to own the stock and lease. But now a lot of these co-ops are easing up and they do. So we have people coming back now all these years later and saying, well, I know my neighbor did this, maybe let's try again. So again, a lot of what we're talking about today is maintenance of your existing trusts. It's time probably to come back in and check out, is my co-op going to let me do this? Should I be putting additional assets into trust to protect them for Medicaid purposes? Have the tax laws changed as such that I need to make a decision or change the way things are? And so creating a trust for these main purposes, and then also the maintenance of the trust, is really important. Just for those who don't know, if you are going to apply for Medicaid to pay for the cost of your care, your assets have to be under $16,800. That's a low number for some people. And so the ability to be able to protect assets like a home, maybe like a cabin that you have upstate that's only worth 30, 40,000, but you love it and it's been in your family for years, that can go into a trust and be protected should you need Medicaid to assist with your care. So that's really important. In your trust, you can create subtrusts. So for those who want to create the trust for the spouse, like we discussed, or perhaps create a trust to protect our beneficiaries, our children, from creditors or divorces, or we might have a beneficiary who is a special needs person. And I'll go into that as my fourth reason we often create trusts. You can make sub-trusts under your trust. So what would that look like? Let's say I have one child and I put my assets in a Medicaid asset protection trust because I want to make sure that my home goes to my child when I die. So my house is in the trust. And then upon my death, my trust reads that when I die, my home should be passed on to my daughter in trust, where it continues on. And I will likely choose that she could be her own trustee. She could have discretion to get income and principal from the trust, but it would be protected from her creditors. And so we like to create those further trusts so that after the death of the original trust creator, the additional beneficiaries are continually protected. The fourth reason that we often create trusts, as I just alluded to, is for a disabled beneficiary that's on government benefits. So if you have a beneficiary who is on government benefits that are means tested, you will want to create a supplemental needs trust, and we call it a third-party supplemental needs trust for that individual. Third party means I am not the individual who needs the care. I'm creating that trust for someone else. Most importantly is this: if I have a disabled beneficiary and I leave the money to them and they have to then create their own trust, that is then a first party, because they're putting their own money, because I gave it to them. Now they're putting it into a trust that has a payback to Medicaid. So where we can, we make it where if I'm giving money to a disabled beneficiary, I am going to be putting it directly into a trust so that they aren't doing it, so that there's no payback to Medicaid. That means that when my beneficiary eventually dies, the assets go the way I say. And I might have given it to a charity. I might have other children I want to give it to, whatever it may be, grandchildren, et cetera. I can dictate that in the document without Medicaid coming back. And if the trust is drafted properly, my beneficiary will have the benefit of all of the things they get from the government, whether it's SSI, Medicaid, whatever the programming is. And they'll have this supplemental needs trust money on the side that can be used to help pay for them, to pay for clothing, for all sorts of things that they may need beyond what their government benefits are covering. And so that's our fourth compelling reason to create a trust if you have a disabled beneficiary. I see that we have the Q&A is not working. But if you would like to email questions, we can field them at info@burnerlaw.com. Also, there is a function where you can raise your hand, and I believe Liz can unmute you if you would like to ask a question. So feel free at this point, if anybody wants to raise their hand, I'm happy to answer questions. I just want to quickly review for those of you that can't stay on with us any longer, that what we talked about was that the main reasons that we create trusts are probate avoidance, tax avoidance, Medicaid protection, and supplemental needs trust for a designated beneficiary. There's many other trusts out there, but those are really the ones that we're seeing most and the ones that we are helping people build for their families and their future. We generally define it in the document as a beneficiary who is on government benefits. So yes, having Alzheimer's can lead you to be disabled. It's not that all people with Alzheimer's are disabled, but that can qualify. So let's say you created a will that said, or a trust that said, if I should die before my mother who has this disability, I would want X amount of dollars to go to her in a supplemental needs trust. That's a great question. So the current law is that your assets, let me say it this way. When you apply for Medicaid to cover the cost of a nursing facility, Medicaid goes back 5 years from that date to determine if you gave anything away. So we talk about the 5-year look back being that if you want Medicaid to cover your nursing home, you need to get your assets into the trust, because that's a transfer, and wait out at least 5 years, because then when they go back 5 years from when you need the care, that transfer isn't going to show up. For home care services, there is currently no look back for home care. So what that means is if I sign a deed putting a house in a trust on January 31st, then technically that individual is eligible for Medicaid, assuming all other assets are in place, on February 1st. There is no look back. However, the law has been in flux since April of 2020, along with a lot of other things has been in flux since April 2020. But basically, New York State wanted to add a 2.5-year look back for home care. So that would mean we would need to transfer assets, wait 2.5 years, and then apply for home care. However, that law has not changed. It hasn't changed for two main reasons. One is because of COVID. We're in a public state of emergency, so we can't change our Medicaid program. But what I think is more important is the federal government has not approved that change. So it is very possible that that won't come into play. The soonest we have to worry about that, real soonest, is July, but as time goes on, I think that that's going to expand. So for now, there is no look back for home care. There could be one in the future, but it's very, very unclear if there ever will be. You are correct. It is not in the probate estate. So anything with a named beneficiary, including a life insurance policy, will not pass through probate. The reason we create irrevocable life insurance trusts are for those individuals where the life insurance death benefit, the dollar amount, would put them over having a taxable estate. So therefore, we want to separate that out so there won't be any estate taxes. So my example before, you have somebody, if the exemption is 6.11 million in New York, and they already have a $5.5 million estate, and there's $1 million life insurance, we would want that life insurance passed out of the estate because we don't want it to bump them over that cliff. So it's only for those who are worried about being over that $6.11 million where we create the irrevocable life insurance trust. Taxable estate and probate estate there's different items that go into those. The taxable estate, let's face it, they really try to tax everything. So there's a lot more included in the taxable estate than the probate estate. So it's going to depend on the exact trust, but usually it's anything where we can change the ownership. So are you talking about, which type of trust are you talking about? For the Medicaid purposes, for the for estate tax purposes?
Most likely for Medicaid.
Okay, so it may not be necessary to. So the only time we have to worry about transferring a life insurance policy out of your name for Medicaid purposes is if there's cash value. So a lot of times with retiree plans, there's a death benefit when you die, but there's no benefit to you while you're alive. So you only have to worry about those life insurance policies that have a cash value, where if you surrendered it today, you'd get a check. And so it would depend on the policy. But yes, otherwise you can change the owner to be your trust. Going to depend on the particular circumstances. You can fully revoke an irrevocable trust. So if you decide down the line, I don't know why I did this, I just want it all out. As long as you and your beneficiaries sign off and agree, you can revoke an irrevocable trust. And then there's other ways, depending on how your trust is drafted, who the beneficiaries are, et cetera, where assets from the trust can be liquidated or freed from the trust. So I would just say check in the your personal circumstances if that would work out. Great question. I love these questions. They remind me of the things I should have brought up before. So you wouldn't. Okay, let me say it this way. If you're talking about a revocable trust or one of the Medicaid trusts, or a trust where you're creating the trust, you can't and you wouldn't for a few reasons. One, if you were to take a tax deferred retirement account and put it in the trust, it would be considered a taxable event. You don't want to pay all those taxes. The second reason is because they are protected assets. They have creditor protection. So for example, if somebody needs to go on Medicaid, they need to have less than $16,800, but they can have a retirement account. So if you have a $300,000 IRA, you can have that and be on Medicaid because it has protection. You just have to be taking your distributions from it because then it's considered a stream of income. So you wouldn't put them. In certain circumstances, and only when the trust is drafted very particularly for this purpose, you can name a beneficiary that's a trust upon your death of a retirement account. So let's say upon your death, you have a 10-year-old granddaughter that you want to receive your retirement account. You can name a trust for her benefit to be the beneficiary of that retirement account. But again, it has to be drafted very particularly to make sure you don't lose certain tax benefits. but it is possible in that instance. But there wouldn't be an instance where the original account owner would put that type of asset into a trust. Still, it can still be invested exactly the same way. The question is going to be, where does that interest go? And when you draft your trust, that's one of the things that has to be determined. In the Medicaid Asset Protection Trust, we can allow for that interest and the dividends to be paid out to the individual. So if you create a trust, you put your investment account in there and you want to keep getting the interest and the dividends because you use that money, that's perfectly fine. You can get that. If you don't want that income because you have plenty of income and you don't want to up the amount that you have because it's more you have to deal with on the Medicaid side, well, then we can turn off the right to income and it can accumulate in the trust. It can be paid out to your children. And there's different tax, pros and cons to each of those choices. And you would just determine with your attorney which was the best way to go. But most Medicaid trusts that we see, especially if they're drafted otherwise, and even here, people do have access to that income because a lot of people still like to get that income.
Mm-hmm.
It is a trust that is drafted for the purposes of protecting assets for when that individual applies for Medicaid. So there's just certain language that goes into the trust and certain powers that the creator of the trust can have and can't have. Short answer, yes. It would be how the trust is drafted, and then also how your daughter would use it. So, you can set up these protections for her. And I only briefly touched upon it before as a quick topic, but we often we call them descendants trusts, but we often create trusts that have that protection from creditors, including divorcing spouses. But there's also certain things that say, like, for example, if your daughter wants that money to be protected from her spouse in case of a divorce, then she can't just readily use that money for both spouses during their life together and things like that, because that has a negative connotation on the divorce end of things. But yes, you can create that kind of trust and create that kind of creditor protection for her. As long as it's your primary, I don't see why you couldn't. We don't do a ton of qperts anymore, the way the tax laws changed and when the exemptions went above $1 million. There was less and less of that. So I believe the answer is that you can do it more than once, but you just want to be very careful when doing that, when you're looking into what the appreciation on that property will be and any potential capital gains tax negatives on that. But, obviously that's all case by case. Answer your actual question first, which was, so yes, there are reasons to do it. And yes, maybe they should be in an irrevocable trust, but I would say it really depends on what you're looking to do. Some people create, in addition to avoiding probate, revocable trusts are often used because people like that the trust has terms for if they become incapacitated, how the assets are handled. So a lot of people like their assets to be under the same umbrella. It's just easier for them to, all my assets are in my trust. So we do often put accounts into revocable trusts. However, the revocable trust does not give any protection in terms of taxes or Medicaid. So that's where you would enter some type of irrevocable trust, whether it was an irrevocable trust for the tax planning purposes or irrevocable for the Medicaid purposes, when you're looking to create some kind of protection. Because you can think of it very simply, right? You don't get anything for nothing. So if you don't give up some control, you can't get the protection. And so a revocable trust, you just have full control over everything. So it's not protecting you from anything except avoiding probate. Sometimes people do different things, right? So some people say, and this is a lot of times it's just stylistically the lawyer or also even the individual's preference. So I have some clients who say, I'm going to take my brokerage account and I'm going to put it in the name of my trust, because then if I become incapacitated, my trustee can handle it. Then the banking institution already has a copy of the trust. It feels more streamlined to me. And then other people say, you know what, I don't really want to do that. It's an extra step. I don't feel like it, but I'm going to do a TOD beneficiary and name the trust as the beneficiary so it flows there when I die. And then other people, those are really what the two options would be if you were looking to avoid probate. So it's really going to be a personal preference of how you would want to do it. Equally to your children or to your, or if you're next of kin or your siblings and you're not leaving everything to them, you're leaving it to friends. You might avoid probate if you have a disabled beneficiary, because that can often make the process longer and cost more money. Quick sale of the property, quick control of the funds, all of that's lost with probate. So there are some people who go through probate and it's perfectly fine, but it's going to depend on what your assets are, what you're looking to accomplish, and then also, what timeline you're okay with being on, or your beneficiaries being on after your death. If you want, well, I guess I would ask questions like, are the beneficiaries that are named the same as the beneficiaries in your trust? Does your trust have different, like, what would be your mindset, right? So some people keep almost nothing in their checking account, in which case, if you name your family member as a joint owner, that's probably perfectly fine. Whereas some people keep, $150,000 in savings or checking, and you would want to make sure that that passes through the trust so that it passes to those other trusts that you might create under your trust. Also, so that it's in control of the person who's in charge of your estate, so that there's immediate access without having to go through legal and fill out paperwork and all that stuff. So it may be that leaving your checking account outside of the trust is perfectly fine. A lot of people like to do that because they don't like their checks to say the name of their trust on them. Not usually, but this is one where I would say, every 10th time that happens, a bank or a bank teller says, oh, we can't accept this, it's not made out. But at least recently, where somebody actually deposited a check made out to their trust, their irrevocable trust, in their personal account, and the bank never should have let it happen. You should not have an issue depositing your check, because you could just endorse it over to yourself, and your revocable trust has your social, and you're the trustee of it. So that it should not be an issue.
So if anyone has additional questions, we have come to the end of our webinar. Please feel free to send those to info@Burner Law. We'd be happy to answer those for you. Again, this webinar will be up on our website along with those other educational topics. And we wanted to thank each and every one of you for taking time out of your day and joining us.
Yeah. I'm not Delilah anymore. I felt like I was on the radio for a minute here.
Yeah. Thank you, everyone. And also be sure to check out our website for our future upcoming webinars as well.
Have a good day.
Have a great day. Take care.
Bye.